Hey guys, I'm back, Anthony Whitlock with video number 3. Today what I want to talk about is easements. There's a bunch of different kinds, of course. Each one is granted a specific way, grants specific rights to specific people, lots, properties, or entities. So let's just dive into the first one, which is going to be ingress and egress easements. I will explain with a drawing here in a second, and we're going to keep going from there. Okay, so this is just an example. What we have, this is the Woods parcel, this is the Jones parcel. Let's say Jones owns up to here, Woods owns up to here. As you can see, this subdivision here owned by someone else, or at least developed by someone else, and now there's 4 individual owners. What you notice right off the bat is you have Dover Street down here, right? There's no other public access for lots 3 and 4. You can get to lots 1 and 2 from Dover Street. You cannot get to lot 3 and 4 from Dover Street without an ingress egress easement. So what's happening here is when this subdivision was created, these little dashed lines here are representing the ingress egress easements that were created at the time. Let's call it a 12-foot corridor, and how it would be granted, it would not be granted to an individual. It would be granted based upon the lots at the time that this subdivision was created. Most likely, sometimes they're not, and sometimes this happens after the fact. Sometimes it goes to court because issues arise. But in this case, these easements were created at the time that this was created, that the subdivision was created. So, an easement appertenant, what that means is it is associated with land only. It's one parcel serving another parcel. An easement in gross is a parcel or a piece of property that an individual or an entity is granted rights to. So entity, let's call it a utility company. That if a utility company is granted a right to a corridor on someone else's property, that is an easement in gross. An easement appertenant would be lot 4 has rights to cross lot 1. This easement here, this ingress egress easement, is an easement appertenant, and lot 4 is the dominant estate. What that means is lot 1 is the servient estate. Lot 1 has the encumbrance. This easement is not a good thing for lot 1 because his lot is forever affected by it. Lot 4 will forever have rights to this corridor of this person's lot. Okay, so that's ingress egress easements. It's a little bit about them anyway, but that's kind of getting you the gist of how those easements, when access is required, how those affect existing parcels. Another thing I want to touch on is implied easements, and they do happen quite a bit, or they used to, probably not as much anymore, but they used to happen quite a bit, and I'm going to explain that a little bit so that you guys can understand some of the things we deal with. I think some surveyors jump into it. They really do. It becomes so commonplace, and it's known that the courts will see things in particular ways, or they're supposed to. But some surveyors think that we have the right to tell somebody, a property owner, what their situation is, whether it's adverse possession, whether it's implied easements. We tell them they may have rights that we don't have the authority to say. It's our job to put properties in place on the ground, put easements where they belong on the ground. And there's particular situations where we may be right, where we say, hey, property owner, you may have a right to this. You may actually own up to this fence line now because that fence line's been there for 20 years and you've been occupying up to it. That's as good as you can call it. You cannot confirm to them that they own this extra property or that this easement exists because of this. That's not our job. The courts make those decisions. We do not. We know the standards. We know what's required, and they may full well meet all those standards. but we cannot tell them that they now own this property over here. We can maybe say you guys may have a right to this, and then eventually they argue with their neighbor long enough, they go to court. The court makes that decision. We do not. And I think a lot of surveyors, because some things are so commonplace, and surveyor really probably is correct, but I think you're overstepping your bounds when you take that leap to tell someone they have a right versus saying they may have a right. All right, so implied easements. Same exact situation as before, right? It looks almost exactly the same. I just left the names off the side parcels. 1, 2, 3, and 4. The only thing missing is those easements, those ingress and egress easements. So what happens in this situation? Guy subdivides the 4 parcels, sells them off. Everyone thinks they're all good, okay. 3 and 4 go to build their house. How do they get to them? They can't without an easement, right? They don't have a right to cross these parcels, right? Well, typically the courts will look at a situation like this and they will call that an implied easement. The courts, not surveyors, the courts will decide if there is an easement granted on these parcels, ingress and egress easement, for parcels 3 and 4. That's just a topic I wanted to touch on because although very commonplace, the courts make those decisions, and in a situation like this, I think any surveyor would say, hey, there's an implied easement here. It's not our call. Courts decide it. This has to go to court for that to be applied, unless 1 and 2 here just are agreeable. They say, yeah, it makes total sense. You can cross my property. Otherwise, yeah, it's just got to go to court, and the courts have to make that decision. All right, so we talked about the easement appurtenance when it's parcel based. Let's talk about this one for a little bit. So as you can see, I added that 50-foot electric easement. This easement in this particular situation would have been pre-existing to the subdivision. The subdivision gets done and obviously encroaches. I won't say encroaches because it's not really an encroachment. It's allowed to be there. It's just a matter of that 50-foot electric easement is going to encumber. It's going to be an encumbrance on lots 3 and 4. So what needs to happen, and what's really important, is that the original description of that 50-foot electrical easement is a good description. You can retrace it for years to come, hopefully. I know a lot of them are not good. They're actually quite terrible from a long time ago. But also that on the subdivision plat, the important thing here is that they do a really good job with the lot description, the exterior boundary of the subdivision, and that the easement is, most states require existing easements encumbering the entire subdivision property will be shown, labeled, identified. I would imagine all states require it, but I am not licensed in all states, so I have no idea. But so as you can see, the easement encumbers lots 3 and 4. That's going to be on the subdivision plat. That easement is owned by an entity. The people who have rights to that corridor is a utility provider. It could be it's probably a private entity, but it very well could be a public entity. They were granted this corridor long before this subdivision existed, and they have rights to it. Until they decide to vacate it, they have rights to it. So lots 3 and 4 now have a strip, we'll call it a 10-foot strip, where they can't do anything with that 10-foot strip that's going to affect the utility company's right to this corridor. Basically what that means is they cannot fence their property all the way around. I got everything tilted, so but yeah, they cannot fence their property all the way around because now it restricts access for these for the utility company. They can see what happens, but if the utility company has an issue with it, then they're going to need an encroachment license to have their fence over that strip of land. If the utility company won't grant them that license, the encroachment license, then those property owners are going to have to tear their fences down. And that's just the way it is. They have rights to it. It's existing. They cannot encroach on their easement. Something else to pay attention to. As a surveyor, you need to be aware of what an exclusive easement is or what exclusive rights are. If there is an exclusive easement granted to whoever in a specific corridor, that corridor cannot be granted across, over, under, whatever, to another person. Rights cannot be granted crossing into that exclusive easement. That corridor becomes exclusive to whoever it was granted to. Well, this is an easement. The owner of the property still owns the ground, still owns it completely, but that person, that whoever entity, whatever he granted this corridor to, you can't grant a piece of that corridor to somebody else for a different use or the same use. So when you're dealing with easements, if a client of yours may say, hey, I need an easement here for whatever, you need to be aware and read that document thoroughly of the existing easement crossing this area, that it's not exclusive. If it is exclusive, no go. Your client's not going to get what he needs. You're going to have to figure out something else. All right, so we've touched on the implied easements, so I want to talk about prescriptive easements. I would imagine you've heard of them. I'm not sure. Prescriptive easement is much like adverse possession, only there is zero possession involved. So basically what it is over time, continuous use, a person can gain a right over someone's property. It can be anything almost. It can be a walking path. It can be a roadway, an access. It can be utilities. If there's overhead utility lines on this piece of property crossing it for a certain amount of time, depending upon which state you're in, a prescriptive right can ripen. So basically, what it is let's go with the walking path. Neighbor A has been walking across neighbor B's property for 18 years over time to his favorite fishing spot at the lake on the other side, whatever. He's using it. It's a clear-cut path now, that's why they say the beaten path. He's made a trail over the years of just walking across this piece of property. Property owner never says anything about it, barely notices, whatever, but it is clearly defined. It is on the person's property. There's no question about it. What I'm getting at is that can ripen into a right, an easement right for crossing that person's property. That person suddenly puts up a fence, says, I don't want you using this trail anymore, whatever. If the guy really likes his fishing spot, he can push back and say, no way, I've been using this X amount of years, I can prove it. You've never stopped me, you've never said anything about it. I think I have a right to use the trail. They go to court. The courts could side with neighbor A who's crossing neighbor B's property and say, nope, neighbor A has a right. There's now a 10-foot wide easement, which is the extent of the trail, whatever it is, and neighbor A now has a prescriptive easement granted to him, and he can use it till the end of time. But yeah, so that it's much like adverse possession. It's using someone else's property for an extended period of time. It's open, notorious, whatever. They now have an easement. You've lost your ability to fence off your property. A negative easement is basically an easement that negatively impacts or prevents the property owner where this easement lies from doing something. It's called a negative easement. For example, there's easements that basically restrict. Let's say there's a building here, we're talking about maybe in the middle of a city somewhere where they have a view of the mountains or something like that. So there's a building here. They have an easement on the parcel over here towards the mountains that says they cannot construct a building over 30 feet tall. So no building over 3 stories tall because it will block their view. That exists. That's a thing. And that's what's called a negative easement. So if you're developing this site, you better do your research and hopefully a title report or something comes up that easement exists and your client cannot build a 4-story building on that parcel. One thing that needs to really be taken into account when writing these descriptions for easements is controlling calls. You can have a platted subdivision with lots platted as 50 foot by 50 foot, and you're trying to grant an easement on lot 5, 50 feet on the west line of lot 5, and you say, thence coincident with, that's a great controlling call, by the way. It's way better than along the west line. So use that, coincident with the west line of lot 5, 50 feet. Guess what? Somebody set that monument, the original surveyor set the northwest corner of lot 5 at 55 feet. Suddenly, you don't have your easement controlling or covering all of the west line of lot 5. You've got it 5 feet short of the northwest corner of lot 5. Those are rare circumstances. 5-foot bust is a rare circumstance anyway, but, a couple tenths or whatever. Yeah, it happens. But you definitely want to use controlling calls. Call to the northwest corner of lot 5. Don't call, you can still use 50 feet to the northwest corner of lot 5, but as we know, that controlling call of the northwest corner of lot 5 is going to control over that distance. So if that thing was set 5 feet north, doesn't matter. If it's the northwest corner of lot 5, your easement's going to go to it. Use those controlling calls, anything, section corners, southern boundaries of other parcels, whatever. You use the controlling calls because those are going to control where your easement sits no matter what happened, if errors happen when those other properties were established. Another thing to go with legal descriptions, there are times where the surveyor is dictating the rights being granted. So it's not that you're never going to do this. There's times you'll come across it, it will happen, you'll need to define this easement is specifically for sanitary sewer, electric, whatever. You're going to define that. That happens. However, most times when dealing with a utility company or even two private property owners who are creating an easement for grazing, cattle grazing or something like that, there may be a lawyer involved. And there's going to be documents preceding your easement description and exhibits. So most of the time, I do not identify anything. I let those preceding documents that come in this package that your easement description is going to be attached to, I let all that information define the use of that corridor and what rights are being granted. If there's a conflict and they say it's a sanitary sewer easement in those documents and you call it a utility easement, public or otherwise, you just call it a utility easement, you've created a little bit of confusion between those grantors, what those grantors signed and everything. That's a sanitary sewer easement. You've now thrown a little confusion into the mix. Stay away from it. You describe the property. That's what we do. We describe where this corridor sits. We don't want to be the ones describing what rights are being granted. I personally work for a public utility, and that's why I don't touch it. There's a 9-page document that goes in front of my easement describing what's what and what their rights are, what their rights are not. So I stay away from it. I just, hey, here's the parcel, here's the corridor. That's where it goes. Whatever you guys agree upon, that's where you can be. That's my job. Overburdening an easement. Is it possible? Can you lose your rights? All that fun stuff. I have worked on a project, just a personal example here. I've worked on a project where an easement, an access easement was granted, an ingress egress, over some farmland, over some cattle grazing land to a city-owned parcel, to a publicly owned parcel of land. What ended up happening is the publicly owned, or the public entity who owned this parcel, decided to build something, decided to construct something. Their only access was through this farmland. And originally, it was supposed to be just access for the city. Well, contractors were hired, construction crews were hired. All of a sudden, everybody is using this access route, this one little corridor, which a road was built over, strictly easement, not right-of-way or anything like that was granted to the city. And all of a sudden, trucks like crazy are going over this parcel. No way. Shut down immediately. As soon as the property owner noticed it and realized what was going on, he called his attorney. Attorney sent whoever a letter, said, "You're overburdening your right. This easement right that was granted to you, shut it down. Cease and desist." And they were right. You can't do that. This public entity was granted access, and they don't have the right to assign that right to other people. From the way this document was written, other circumstances, documents have been written where they do have that right. So, like I said, legal descriptions and those documents, which are granting all those rights, they're really important. They need to be understood. Just because it doesn't say easement doesn't mean it's not an easement. Just because you see right away does not mean it's owned by a public entity. It very well could be just rights granted to the public entity. Be aware, read your stuff. The research is the most important part of what we do. It really is. It's everything. If you miss something in the research, you're doomed. I mean, if it's important and you miss it, if there's a problem, you're getting blamed, and that's just it. You know, a lot of us today rely upon title reports for that reason. And even in the title reports, those guys, they put in their little disclaimer notes too. It's just, being a surveyor, you're probably going to end up with the blame no matter what the hell happens. It's unfortunately one of the downfalls of our profession. For whatever reason, surveyors get blamed. But don't put yourself in that position, especially if it's avoidable. Avoid liability. We're going to take it on. That's what we do. That's a lot of what we get hired for, but you don't want to get sued for a simple, stupid mistake of just missing something in the research because you skimmed it instead of read it in detail. God knows I don't. Doctrine of Merger. What is that? That affects us greatly. Let's say Lot 4, like we were talking about before, there's an easement across Lot 1 to access Lot 4, right? The owner of Lot 4 at some point purchases all of Lot 1. That Ingress Egress easement is extinguished. It no longer needs to be there because the owner of Lot 4 now owns Lot 1. You can't have an easement for the benefit of you on your own property. It doesn't make any sense. Let's say Lot 4 purchases Lot 1. That easement goes away. Guess what you're dealing with again? Lot 1, he decides to sell Lot 4. He keeps Lot 1. He decides, I've got both lots. I don't need both lots anymore. I'll keep one since it's closer to the road. I don't like plowing the driveway, whatever the hell. So he sells Lot 4 to somebody else. They don't create that Ingress Egress easement again. That one's gone. It doesn't come back just because he sells off Lot 4 again. It's gone. Hopefully, he's reasonable enough to expect, yes, that person's going to have access through my property. I'm just going to, maybe not say anything about it. Maybe just that's his expectation and no official easements created. However, if he wants to go down that route of let's go to court because that easement doesn't exist anymore or whatever, blah, blah, blah. Something to be aware of. The easements can be extinguished by merger of title. That's a common practice. That's a common thing. You'll come across it sometime. Do not just assume that easement exists again. Chase that title back. Make sure that easement has not been extinguished by title of merger, and then you tell someone else this easement exists.